It is my pleasure. I think maybe he almost needs no introduction, but our speaker today is from UC Davis Law School. Aaron Tang graduated summa cum laude from Yale University in political science. He had a very interesting career as an organizer and a middle school teacher. That's Dante's level of hell, isn't it, in middle school? Yeah. And then he went to Stanford Law School, and he ended up clerking for the Fourth District Court of Appeal Judge Harvey Wilkinson, and then he went on to clerk for Justice Sonia Sotomayor of the U.S. Supreme Court. We always wait with great anticipation for Aaron Tang to present to us. I think the anticipation today is probably tenfold. Yeah. Okay. So thank you and welcome to our speaker.
I have a mic. Can everybody hear me? I have a, yeah. I'm going to stand up here too, if folks don't mind. Everybody see okay? Okay. Yeesh, where to begin? You don't need me to tell you that these are remarkable times when it comes to the assertion of power by the current president of the United States, the sheer number of legal challenges that have been filed in court in response to various executive orders, presidential acts. It's truly unprecedented. So it'd be easy and maybe even a little bit tempting for us to spend the next hour in like maybe an open-ended grievance session where we talk about whatever presidential action is on your mind and how they might violate the law, what the Supreme Court would be likely to do. But I'm going to try for a little bit more organizational clarity. So I'll be organizing my thoughts today in what you might think of as three buckets that correspond to three different moments in time or stages in the life of a constitutional lawsuit. Okay, so what do I mean by that? Well, ordinarily when legal talking heads get up in front of an audience, we actually really only talk about one of two moments in time in a constitutional lawsuit. The first bucket is everything that happens before we get to court. It's the action by the government, and it's the pain, the harms, the consequences that are felt by everyday Americans up until the point at which a court decides the legality of what the government has done. Right? This first stage of a constitutional lawsuit, you might think of as like the real human costs of government action, potential misconduct. And lots of coverage in the news today is about this first stage. Maybe it's the most important window, the most important thing that we can shine a light on, because it's during this period in time that Americans are feeling the harms of things like Trump freezes to funding for cancer research at the National Institutes of Health, the president's freezing of foreign aid through U.S. aid to international developing countries, of course, the tariffs that have roiled your retirement savings and mine, to the removal of people under the Alien Enemies Act without due process. So we'll talk a little bit about that first bucket, what those harms are. The second bucket that, frankly, people like me love to talk about is the lawsuit itself, right? This is the second stage in the life of a constitutional lawsuit. Somebody goes to court, they sue because of all these harms in that first bucket. What's the law say? Right? Are there legal arguments to constrain, strike down, and validate what the president has done? What is the Supreme Court likely to do? Right. So I usually talk about this bucket. I love to prognosticate. We'll do a little bit of that too. What the court is likely to do. I won't promise to get any or all of it. Certainly not all of it. Right. But I'll do my best. And that's typically it. Right. When public intellectuals talk about the Supreme Court, these are the two buckets. I've spoken with this group a few times now. This is what I've done. I've talked about the big issues that are at the court, how people are affected, what the court's going to do. This is the first time ever that I have to talk about a third stage in the life of a constitutional lawsuit. It's the first time in my life as a lawyer, as a teacher, that I talk to my students about this new moment that matters. And it's this: what happens after a court rules? What happens after the Supreme Court of the United States issues a decision saying something the government has done, the president has done, is unlawful, right? We've never really had to think about that first stage because it's pretty much been assumed as a basic norm in our civic society that if you lose at court, whether you agree, disagree, you think it's reasonable or not, if you lose at the court, you're going to comply. If you're the defendant, if you're the federal government, you're the president of the United States, you do what the court orders you to do. Now, that's not always been 100% observed. There have been different points in time when, maybe during the civil rights movement, recalcitrant state governors refused to integrate public schools, and there were disputes over that. Dwight Eisenhower had to send in the National Guard, right? That kind of disobedience in the face of a contrary federal court order is the exception. Even when the far left wing of the Democratic Party encouraged Joe Biden to ignore a number of adverse Supreme Court rulings over the past 4 years, President Biden never seriously considered the path of open defiance. Okay, so we need to talk about that third stage. This third stage, maybe it's best thought of as sounds ominous, but I think it's not an overstatement to call it the constitutional endgame. Right? It's the end game of a lawsuit, the possible end game of a democracy. If the court rules against the president and the president says, no big deal, so what? Courts told me to stop deporting people. I'm not going to stop. What then? Right? What options are available to us as a people? What options are available to the courts to try to bring into line a president who refuses to comply? Okay, so I'll talk about that at the end of the talk. All right, that's the outline. So let's talk a little bit about this first stage in the story of constitutional litigation, the harms of the president's world-changing actions. Okay, so again, you don't really need me here, right? You're all concerned citizens, highly educated citizens. You wouldn't be here otherwise. So you know from the news that people in America, everyday people and around the world really are suffering due to actions from this administration. But I think maybe the most important thing I should say about it is that some of the suffering is actually perfectly normal. Sometimes, from a constitutional perspective, elections have consequences, right? And every president is going to do some things that make his voters happy, that burden, that upset the other side's voters. And in truth, a lot of the times when this suffering happens after a presidential election and presidential action, I have no quarrel with it from the perspective of the rule of law. I have no quarrel with it from the perspective of our constitutional system. Right? I have no quarrel because usually the proper response when you lose an election, whatever your side is, the other guy comes in and does stuff that you don't like. The usual response is you redouble your efforts to win the next election. You vote the other guy out, you bring your person in, and you hope they fix whatever the harms were. Right? So to give an example, the first law, and honestly the only law Congress passed for the first 2 months it was in office, passed one law. President Trump enacted over 100 executive orders. One law Congress enacted in the first 60 days of its term was a bill called the Laken-Riley Act. And if you followed this, it was a law that required ICE to use its arrest power, to actually go and arrest and hold in federal detention people who are undocumented, unlawfully present in the United States who have been convicted of shoplifting or theft or burglary offense, right? Previously, those individuals weren't required to be arrested. They would be removed through civil process, but not the criminal arrest provision, right? Okay, so Congress passed that law. Maybe you disagree with that policy. Maybe you think it would be better not to arrest these individuals, not a high priority. But constitutionally speaking, the system worked as it should have, right? We had an election. Opponents of the Laken-Riley bill of that position lost. The law got changed. There are harms, but to fight back against that law, you have to win the next election. That's the way the system's supposed to work. The harms that are different, the harms that we really want to focus on in this moment, that I'm going to talk about in this first bucket of our constitutional story, these are harms that occurred not because the president, his party, his administration followed the rules of the constitutional system to enact things like the Laken-Riley Act, but rather because the president took acts that broke democratic norms, that did not operate through the usual democratic process, right? Rather than doing what Congress said he could do, which is go to court. If he wanted to rescind an order against Kilmar Abrego Garcia and remove Mr. Garcia to El Salvador, in the face of a federal court order saying you can't do that, he could have gone to court. He could have shown evidence that Mr. Garcia was, in fact, maybe a member of a gang in violation of federal law that allows for his immediate removal. Could have followed that system. And if he had, and Mr. Garcia was removed as a result, that's the way the law works. Maybe we feel bad for Mr. Garcia and his family, but that's our system. But instead, right, the administration just shipped him to El Salvador, no due process, openly admitting a mistake, does nothing to bring him back, right? Rather than passing a statute, right? If the president wants to terminate cancer research funding or aid to foreign nations or teacher training grants here in the state of California, there's a system for that. It's called Congress, right? If the president had gone to Congress, passed a bill, cut all that funding, a bunch of people would be hurt, but that's the way the system works. Instead, the president unilaterally, without an act of Congress, decided, I'm just not going to spend all this money. Congress passed laws saying I have to spend, right? That is a different kind of action and a different kind of harm. To give another example, right? Rather than going through the United States trade representative, who's a federal officer, an executive officer that Congress is given the explicit statutory authority to impose retaliatory tariffs against foreign countries if the trade representative initiates an investigation, finds maybe unfair trade practices by a foreign country, burden on United States commerce, totally fine to implement tariffs in response to those actions. But of course, that's not what the president did. The president issued across-the-board tariffs on so-called Liberation Day without any findings, any process at all. Okay, so across these settings, what we're seeing is real pain for Americans, right? Millions of Americans have seen their retirement savings hit by the tariffs, uncertainty in the stock market. Hundreds of thousands of federal employees have lost their jobs because of the so-called Department of Government Efficiency coming through and slashing various federal agencies and departments, despite statutory protections these folks have for their jobs. Undocumented folks and even lawfully present people in the United States have lived in fear of being targeted, removed by ICE. And of course, doesn't even begin to touch the long-term pain from funding cuts to research, to U.S. aid, teacher training programs, right? Those harms are difficult to measure, but almost certainly we're talking about lives that will be impacted or even lost down the road. Okay, I want to say one more word about the harms before we move to the second bucket, the second stage, the litigation itself, which is that in some ways the fear, the uncertainty that has been produced in response to all these presidential actions, in some ways that's the point for the administration, right? Maybe the Trump administration believes it has a mandate to crack down on brown people, to remove them, due process actual innocence of individuals, be damned. Maybe the administration thinks it has a mandate to save money for taxpayers, firing federal workers and freezing grants. But the administration, I'll tell you, also believes this. Even if, as may well be the case, the court ends up ruling against them on a lot of what the president is doing, it will have accomplished something that it likes in the meanwhile. It will have made life intolerable for lawfully present and undocumented folks alike who might choose to leave the country. It will have made employment as a grants manager for the United States Department of Education or a researcher in the National Institutes of Health. It will have made it so unpredictable and unsafe that people will stop doing this important work, right? Okay, so that's the harms. You're familiar with all that. Let's talk about the law, the constitutional litigation itself, what happens in court. What are the arguments that lawyers can bring, that lawyers are bringing to try and push back against these various presidential actions? Right, you're probably wondering, can the president do any of these things that he's doing? Let me give you my best sense, issue by issue, for what I think the law objectively, even-handedly requires, and I'll tell you what I think the court is likely to do on them also. Okay, so I'll start with an issue where the Trump administration is going to win. It's 100% guaranteed. And that issue is this. Suppose Congress tries to create a federal agency with a mission that the Congress thinks ought to be insulated from politics, right? Maybe it's labor, unions. This is something that the law should be implemented neutrally by experts, regardless of whether the president is pro or anti-labor. Or securities regulation, stock market fraud. Maybe this is something you think experts at the Securities and Exchange Commission ought to be able to regulate, even if the president is pro-business or anti-business. You want politics out of some kinds of laws. Congress creates agencies to do this work. Can Congress insulate the leaders of those agencies from the president and say, you can't fire these folks, Mr. President, the heads of the National Labor Relations Board or the Securities and Exchange Commission, unless they did something really bad. They were negligent, malfeasant, right? You can't fire them unless the law says you have, quote unquote, good cause. Can Congress do that? Can it create independent agencies? And for 90 years, the Supreme Court's answer was, sure, absolutely, that's fine. There are lots of agencies where we want neutral expertise in the hands of experts to make these kinds of regulatory calls. And so in 1935, the Supreme Court decided a case called Humphrey's Executor. And it said that limits on the president's power to remove the heads of so-called independent agencies, they're fine. Well, Humphrey's Executor is as good as dead as Humphrey himself. All 6 of the conservative justices have expressed a desire to overrule that decision, and there's now a case working its way up through the federal courts involving the former member of the National Labor Relations Board, a woman named Gwen Wilcox, in which Donald Trump fired her without good cause, even though the statute said he needed good cause. And the court's going to rip off the Band-Aid in that case, or maybe another one, and say the president can fire anybody, any of his officers, at any time for any reason. Right? Congress cannot limit the president to firing them for good cause. And you might say to yourself, of all the things that we've talked about today, this one may be not so worrisome. How much does it really matter who's in charge of the Securities Exchange Commission or the National Labor Relations Board? I can tell from the reaction that you don't buy that. But I will say this, there is a certain symmetry to whatever decision the court rules. When the court overturns Humphrey's executor, right, that might help Donald Trump right now. He can put in office the people he wants. But if and when we have another election, and if and when a Democrat wins, that president will just be able to remove Donald Trump's appointees too, right? So the real net impact of the Supreme Court's making agency heads directly responsive to the president is just to make elections matter more, right? The NLRB, the SEC, right? That their enforcement is going to mimic whoever we put in the Oval Office. Okay, so why should we care that much? Well, it's not the NLRB, it's not the SEC. That's not why we ought to care about Humphrey's executor. It's the Federal Reserve. It's the Federal Reserve because just last week you heard Donald Trump float this idea that maybe he would like to fire Jerome Powell because Jerome Powell is not making money, is not adopting a monetary policy that makes people feel wealthy in the moment. In other words, the Federal Reserve doesn't like inflation, right? But a president of the United States, only who cares about their own legacy, fine, inflation's the next guy's problem. Make people feel rich in the here and now, so I'll be popular. That's why he'd like to fire Jerome Powell. He can't do it under existing law. He can't fire Jerome Powell because Congress made the Federal Reserve an independent agency, and members of the Federal Reserve, the chairperson, can't be fired unless, wait for it, the president has good cause, right? The same removal limit that is likely to be struck down in the NLRB case, that's the removal limit that applies in the Federal Reserve context too. So if you thought the stock market, mostly this, after the tariffs was bad, right, it's going to look like nothing compared to what will happen to international markets if Donald Trump's allowed to fire Jerome Powell. So if there's any luck, and here's where we get to prognostication on this issue, it's this: all 9 members of the Supreme Court own stock too. They all have retirement savings. They all have mutual funds. They're not dumb. They know what would happen if presidents can just remove the Federal Reserve chair for political expediency. None of them wants to see their retirement savings, their kids' retirement, right, torpedoed either. And actually, in 2 opinions, Supreme Court opinions so far, where the Supreme Court has pared back what Congress can do to fetter presidential removal power, the court has dropped footnotes saying, we think this case isn't about the Federal Reserve. We just want everybody to know that we know that the Fed is different, right? So when the court overturns Humphrey's executor, almost certainly it will add a footnote again saying whatever we are announcing for the NLRB, not true for the Federal Reserve as well, or so we can hope. All right, next issue, tariffs. This one's harder. It's not a guaranteed victory for the Trump administration. I think there's actually a good chance, maybe 50%, maybe a little bit higher, that the Supreme Court could hold that the president lacks the power to implement these so-called liberation tariffs that roil the economy. And the main reason is something that's called the major questions doctrine. Okay, major questions doctrine, what's that? Okay, it's a rule that, if we're being honest, was invented just a few years ago by the Supreme Court, the conservative justices of the court, that says that in order for the executive branch, the president, to implement a new rule, to take some action on a matter of major economic and political significance, the president, the agency, has to point to something in a statute that Congress passed telling the president you can do this exact thing. Right? If it's a major question, if the president wants to take action on a major question, he needs clear authorization from Congress. Okay, I'll be honest, that doctrine, the major questions doctrine, it's bunk, it's baloney, it's a judge-made rule, has literally no source in a federal law or in the Constitution. The conservative justices came up with the rule because they were unhappy with Biden administration actions on major questions. So when the Biden administration considered the possibility of imposing a cap and trade system to regulate greenhouse gas emissions from coal-fired power plants, the Supreme Court said, oh, that's a major question. Joe Biden can't do that if Congress hasn't explicitly told him he could. Right? Joe Biden tried to forgive student loans for millions of student loan borrowers. He had a statute pretty strongly suggesting that would be fine. You can waive or modify. The statute said Congress said the president can waive or modify any student loan provision in a national emergency. And Secretary of Education Miguel Cardona is like, okay, I waive student loan payments up to $10,000 during COVID, a national emergency. And the Supreme Court said, no, 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 no. This is a major question. You need something more clear than the power to waive or modify during a national emergency. What exactly that would have been, I'm not sure, but maybe you have the power to waive or modify during COVID, right? Well, if these rules, this major questions doctrine, is good enough for the court to strike down big Biden administration actions, the same rule ought to be true for Donald Trump too, right? And the tariffs are a perfect example, right? What Trump tried to do before he paused them was impose tariffs that would cost taxpayers $150 billion a year, maybe more, depending on the model. No question that's a vast issue of vast economic and political significance, a major question by any account. So if the court applies this rule neutrally, even-handedly, Donald Trump would have to point to something in a statute saying you can impose these huge tariffs whenever you want to, or for whatever reason you want to. But the statute that Trump points to doesn't have anything like that kind of clear authorization. He has relied on a statute called the International Economic Emergency Powers Act. That statute gives the president the power to declare a national emergency due to some extraordinary and unusual threat. He's declared one, but not clear what that threat is. And it says if that threat exists, that emergency exists, you can take certain actions. And there's a list of actions. None of them are tariffs. Right? At most, the closest thing is he's allowed to, quote, prevent or prohibit a transaction involving any property held by a foreign state or foreign national. Sound like tariffs. Certainly no more than a national emergency sounds like COVID. So if the court applies this doctrine right to the tariffs, there's a strong argument that the tariffs should be unlawful. Okay, next big issue, birthright citizenship. So as you likely know, the president issued a very controversial executive order seeking to deny citizenship, United States citizenship, to the United States-born children of parents who are undocumented, right? Among others, actually extended to some folks here on student visas as well, children born to them. That order, the order denying birthright citizenship, led to immediate litigation. It's already been blocked in lower courts. So right now, the status quo is business as usual, as has been true for 100 years. If you're born in the territorial United States and your parents are undocumented, you're still a citizen. The Supreme Court did grant review. It's hearing an argument in a few weeks on a very technical question about whether the lower courts, the federal district courts that blocked the Trump birthright citizenship order, had the power to impose what's called a nationwide injunction, right? In other words, not just to protect the named plaintiffs and parties in that case, but to extend relief blocking the Trump order across the country against any undocumented person. But what's really notable about that is what the Trump administration didn't ask the Supreme Court to do. The Trump administration did not ask the Supreme Court to agree with its interpretation of the Constitution or agree with its decision to deny birthright citizenship, right? The Trump administration signals, in other words, that it understands it might well lose, probably will lose on this substantive question of who can become a citizen or whether undocumented persons, children born in the United States, are citizens. That's pretty remarkable. And I think it's the Trump administration's right to know it's going to lose on this ultimate question for at least three reasons. The first reason, and the one that most folks have concentrated on, is the Constitution itself. Right? So you may know that the 14th Amendment itself, the United States Constitution, provides that, quote, all persons born in the United States and subject to the jurisdiction thereof are citizens of the United States. Right? So it's long been understood by the Supreme Court itself that born in the United States means born in the United States. If you're born in the United States, you're a citizen, right? Now the administration argues that middle phrase, right? You don't have to just be born in the United States, you have to also be subject to the jurisdiction thereof, that phrase maybe excludes the US-born children of undocumented immigrants. That's an interpretation, though, that's been rejected for over a century by the Supreme Court, by Congress. They've interpreted that phrase. What does it mean to be subject to the jurisdiction thereof? It just means you can be touched by the law. You can be prosecuted if you break the law. Certainly undocumented immigrants can be prosecuted, and the children can be prosecuted if they break the law. Who doesn't it reach? It doesn't reach the children of foreign diplomats. Right? If you're born in the United States and you're like the son of an ambassador, you're not a United States citizen, even though you were born in the United States, because you're not subject to the jurisdiction of American law. You're subject to French or German law or what have you, right? Also true if you're born on an Indian reservation, right? You're not automatically born a United States citizen. Indian reservations, Indian tribes have separate sovereignty. You're subject to their jurisdiction, right? So that's what that phrase was meant to capture, not the US-born children of undocumented immigrants. But even if somebody were to find that constitutional interpretation question hard, there's an even simpler reason why the president is going to lose here. And it's that regardless of what the Constitution says, there's a statute. Congress has passed a statute that has long been understood, 80, 70, 75 years now, to give citizenship, to extend citizenship to the US-born children of undocumented parents. Right? So even if the Constitution doesn't automatically give birthright citizenship to this group, shouldn't matter. That the Constitution is just a floor. It's who automatically gets citizenship. Congress has passed all sorts of statutes to give citizenship to a bunch of people who aren't mentioned in the Constitution. And this is another situation, right? And in fact, it's even worse for the administration. Congress has considered bills to change the statute to do what the president wants, to revoke birthright citizenship for undocumented immigrants' children. That's a strong indication they know the current law does give citizenship. They wouldn't try to amend the law if they thought they were already had the right interpretation. Right, so everybody has understood all along until this administration, US-born children of undocumented persons enjoy citizenship in virtue of their birth. Right, the last note is this is another major question, right? The same doctrine, like who should be a citizen in the United States? That's a big, major question. It's hotly debated. It's got economic significance. Congress, not only did Congress suggest that it wanted these individuals to be citizens, it certainly has never given the president the unilateral power to change, override what Congress has written, right? But that's what the president would need. He would need something like, we Congress declare these people citizens, but we want to give the president the power to rescind birthright citizenship if he wants. Nothing like that in federal law. Okay, next big issue, funding. Can the president unilaterally freeze funding for cancer research, international aid, public health, right? Sometimes you lose track of all the things that are happening. I don't know, like a few weeks ago, it turns out the Secretary of Health and Human Services, whoever that person is, decided he didn't want to spend money on vaccines for children. So $12 billion that Congress had appropriated for public health to the Centers for Disease Control, much of which was for vaccines for children, right? The Secretary of Health and Human Services is like, no, we're just not going to spend that. Sorry, Congress, I know you passed the law, but the president has the power unilaterally not to spend money that Congress has directed. Can you do that? Here again, I think the answer is no, and that the Supreme Court is likely to reach that conclusion too. The president's going to lose. And that's because there's a simple separation of powers principle here, right? In our constitutional system, there's a clear answer as to which branch of government gets to decide how money is spent. It's not the president, it's Congress, right? Article 1, Section 8 says Congress has the power to spend for the general welfare, not the president. I will say this, there is an argument that the president could make that is theoretically plausible. Okay, so I want to try to give credence to the other side when there's a plausible argument. Here's the kind of argument you could buy from the president. Suppose Congress were to pass a law that said, we hereby appropriate $10 billion for this purpose. And the president can spend $10 billion for that purpose, but he doesn't have to spend it all. Right? He can spend up to $10 billion. Then if the president were to come back saying, I choose to spend zero, right, because Congress said I could, that would be an argument that could work, right? And then you could even take it a step further and you could say, well, what happens if Congress is a little bit vague about it? What if Congress just says, we hereby appropriate $10 billion for this? It doesn't say the president has to spend it. The president can spend up to that amount. Right? You could be like, oh, maybe implicitly Congress is okay with the president trying to save money, right? Congress passes laws making certain things crimes, but everybody agrees that the president has some discretion, can choose not to prosecute every single instance of that crime. Maybe spending is the same way, right? So it's not a crazy argument as far as it goes. But here's the problem for the president, if he wants to rely on that argument, is that Congress has passed a law setting the exact opposite assumption, the exact opposite default baseline rule, a statute enacted in 1974 called the Impoundment Control Act. Congress said that whenever we authorize money, anywhere there's a federal law where we authorize a certain amount of money to be appropriated for spending, we mean you have to spend all of it. That's what we mean. If the president doesn't want to spend any of that money, we're open to it. He can send us a report saying, hey, I think I can save you some money here. I can get done what you wanted to get done with less money. And if that's true, Congress said in the Impoundment Control Act, we can pass a resolution. If both houses agree that the president shouldn't spend that money, he can save the money for the American people. But if he doesn't do that, if we don't pass this joint resolution, he has to spend the money, right? Congress has been very clear the money needs to be spent. That statute, by the way, the Impoundment Control Act, was defended very capably by a conservative lawyer then in the White House, future Supreme Court Justice William Rehnquist, who was the mentor, the justice for whom Chief Justice John Roberts clerked. Right? This is a very conservative individual putting a big rubber stamp saying this is absolutely, the Impoundment Control Act is permissible. Congress has the power to decide how much to spend. Okay. Of course, this Supreme Court could do anything. I've definitely been wrong before, probably in front of this group. You could go back and count my errors. And I'll probably be wrong about one or two things today. But if you want to be sort of legal realist, cynical about it, here's why I think even some of the conservative justices will join in a ruling saying Donald Trump cannot unilaterally cancel spending for things he doesn't like without an act of Congress. So if he can do it, Democrat can too. Right? You better believe the Democrat president that comes in next time is going to say, gosh, do we need to spend $850 billion at the Department of Defense? I'd like to save some of that money, right? And if the conservative justices don't want that to happen, right, this is where they shut the door here and now. Okay. Oh, and of course, the same major questions doctrine that I talked about also applies here, right? Unilaterally canceling $12 billion for kids' vaccines and public health, that's a major question. You know, Bobby Kennedy needs to point to something, sorry, Robert RFK needs to point to the wrong, yeah, different Kennedy, very different. Needs to point to something very clear in the statute, in the organic statute creating the Department of Health and Human Services, saying the secretary can unilaterally cancel money for children's vaccines whenever he wants to. Nothing like that at all, right? Okay. Next. Okay, so this is the last big legal issue that I'll talk about, and it'll be a good segue to talking about the third bucket, the constitutional endgame question. Okay, so this last case, this last question involves the removal of people from the United States under the Alien Enemies Act. Okay? This is a federal statute enacted in 1798 during the John Adams administration. The president has invoked that statute to remove, as you probably know, 3 planefuls of individuals, shipping them to El Salvador, where they're being held in a sort of notorious prison. There's a lot to be said about the legal issue, but let me just start by getting out the bare facts so we know what's going on. Okay? So on March 15th, President Trump issued a proclamation declaring that the United States was under invasion by Tren de Aragua, a transnational criminal organization, a gang based in Venezuela. Okay? And when he did that, he said that because we're under invasion from Tren de Aragua, this 1798 law, the Alien Enemies Act, allows me to remove any citizen any person affiliated with that gang, right? So the 1798 statute, what does it say? Under the Alien Enemies Act, a president can remove a citizen from a, quote, hostile nation whenever there is a declared war between the United States and that foreign nation. Okay? So the administration ships off these plane loads of folks to El Salvador, saying they're members of Tren de Aragua. I'm okay under the, we can do this under the Alien Enemies Act. But of course, if you were listening to the statute, right, you don't have to have gone to law school to see that there's a problem for the president, which is that Tren de Aragua is not a foreign nation. And even if it were, there's no declared war. Congress hasn't declared war on Tren de Aragua, much less against Venezuela. So the factual predicate, the whole legal basis on which the president is trying to remove individuals to El Salvador is unlawful. It's not something, he's not authorized to do this under the statute that says that he thinks he can. But that's not even the problem, right? The big problem with the Alien Enemies Act removals, I think, is more basic. It's the thing that should concern us more, which is that the planes that flew out and brought these individuals flew out in contravention of a federal judge's order. Most problematically, one of the people on those planes, a man named Kilmar Abrego Garcia, who you've probably seen in the news, he was removed and sent to El Salvador, even though a federal judge had issued an order saying that Mr. Garcia cannot be removed to El Salvador because there's evidence he's been targeted by a gang in El Salvador, and if he's sent there, his life would be in danger. Okay, so if you followed this case at all, perhaps you've seen that the Trump administration insists that Kilmar Abrego Garcia is actually a member of a gang called MS-13. It's based that allegation on a confidential informant's tip given about a decade ago to a police officer in Maryland who was later fired for misconduct. I have no idea if Mr. Garcia is a gang member or not, but it shouldn't matter. If he is a gang member, right, he should be removed from this country. That's what the law requires. And there's a process for doing that. Donald Trump was perfectly free to go back to the judge who issued the protective order and say, hey, listen, facts have changed. You issued this order. We thought he was a lawfully present person, not violating laws. Look at all this evidence. He's actually a member of a gang. That's a crime. He's now removable. And every federal judge presented with evidence, if it was in fact credible, would say, yeah, absolutely. I rescind my prior order and let's remove him, right? But what the Trump administration did was none of that. Didn't follow the legal process we have for removing people, accusing them of crimes. Instead, shipped him to another country. No opportunity to contest his removal. And then, this is the real concern, the government refused to fix its mistake, right? What's really remarkable, everything I've said just now about Kilmar Abrego Garcia, the government would agree with it. The government has said, yeah, we screwed up. We shouldn't have sent him out. There's a court order saying he belongs here. We made a mistake. He should never have been sent to El Salvador. So the court, the Department of Justice, the United States government has said this. So federal district judge Paula Sinnis in District Court of Maryland said, okay, let's bring him back. Right? I'd like you to facilitate his return to the United States. The Fourth Circuit Court of Appeals agreed. The United States Supreme Court agreed, saying, yes, please facilitate Mr. Garcia's return. We agree it was a mistake. And the government did nothing. It's been 2 weeks. For 2 weeks now, it has insisted that, sure, it screwed up. Never should have removed Mr. Garcia. Never should have sent him to El Salvador where his life is in danger. But now that he's there, there's not anything we can do, says the president. Even though the court is ordering us to bring him back, we can't fix our mistake. That's pretty shocking. What I want to focus on for the rest of the talk is this. What happens if 2 weeks of the government dragging its feet and not facilitating his return turns into 2 months, turns into 2 years, right? What happens if the Supreme Court, if its orders just go openly defied by this president of the United States? What happens to our constitutional system then? And I just want to say it again, like, this is incredible that we're talking about this, right? Throughout our history, there has been a norm. At the end of the day, our entire country, it only exists because of norms, right? And this one norm, we just assume it will always hold, is that the president loses at the Supreme Court, he will do what the Supreme Court tells him to do, right? Even when Richard Nixon lost in a unanimous 9-0 opinion, the Supreme Court said you have to turn over the secret White House tape recordings showing that you obstructed justice and you tried to impede the Watergate investigation. Richard Nixon turned over those tapes the next day. right? And he had to resign. He had to lose the highest office in the land because he complied with the order. So strong was this norm that we follow adverse court rulings no matter what. Well, that is a norm that this president has, I think it's fair to say, broken, right? By refusing to bring Mr. Garcia back to facilitate his return, which he could do with a simple phone call to the president of El Salvador, or the threat to cancel the $6 million that we're paying El Salvador to house and prison these individuals. By refusing to do that, the administration is openly defying this court order, the Supreme Court order. Okay, so what's going to happen next? This is the end games story. It's a scary place to be for us to be talking about this. Supreme Court justices have no army. Right? It's often said that the Supreme Court is the least dangerous, the least powerful of all of the branches of our government because it has neither the power of the sword nor the power of the purse. All it's got is hopefully the credibility it's earned from its prior decisions, the force of the reasoning of its opinions. But if it issues a ruling telling the President of the United States to do something, he doesn't do it, what's left? So the only inherent means of authority, this is going to get a little bit nuts and bolts, but I think you should know. The only inherent means of authority that a court has to order a non-complying defendant to follow the court's ruling is a judicial order of contempt. Right? It can hold a non-complying officer, a lawyer, a defendant, and an officer of the federal government in contempt of court. And contempt orders can be enforced in one of two ways: imprisonment or fines. So you might think imprisonment sounds potent, sounds promising, right? If the courts can imprison Donald Trump's attorneys at the Department of Justice, can imprison officers at the Department of Homeland Security who are the ones saying, don't bring him back, we're not going to bring Mr. Garcia back, that you'd think eventually the president's going to run out of people who are willing to sit in jail to stop Mr. Abrego Garcia from having his day in court, right? Again, just to be clear, we're not saying Mr. Abrego Garcia should come to the United States and live as a free person. We're saying he should come to the United States, and if the president has proof that he's a member of MS-13 and wants to remove him, they can remove him. They just need to show that proof in court, right? How many line-level lawyers at the Department of Justice are going to sit in jail to do the president's dirty work? There's a problem, though. Who's going to do the arresting? Yeah. Right? The ordinary approach, in order to enforce a criminal contempt order issued by a federal court, somebody has to arrest them. That somebody is the United States Marshal. Right? The United States Marshal enforces contempt orders, imprisons individuals. The United States Marshals work for the Department of Justice, sub-agency under the Department of Justice. That means their boss is Pam Bondi, the United States Attorney General. Attorney General Bondi going to order a United States Marshal to arrest whichever lawyer. It's now Drew Ensign is defending the president's decisions in court. Seems very unlikely. Even if Pam Bondi, right, said, you know what, I can't be a part of this. I'm going to order the arrest. Donald Trump will fire her. And we think Emile Bove, whoever the number 2 person is right. Eventually, the president's going to find somebody who will tell the marshals, don't arrest our people, right? Okay. So much for imprisonment. That leaves one option: fines. This probably isn't where you were thinking, the republic is going to be saved when we mentioned it. But this is actually a little bit more promising potentially, right? Federal courts can enforce contempt orders by issuing fines against the judicial officers, the lawyers, the defendants, DHS officers, by issuing fines against them in their personal capacity, saying every day that you don't comply with this order, you owe $1,000. Let's start with $1,000. If you go a week, it's $10,000 a day, right? They can make it. They can make these fines such that the officers can't be reimbursed, indemnified by the federal government. They can make it really hurt, right? And these folks, these lawyers, line-level lawyers, right? They have kids, they have retirements, right? Are they willing to go bankrupt to further the president's wishes, right? So when we get to the bottom of it, this is what it looks like, right? The best chance that we have to make sure the president of the United States is following an order issued by the Supreme Court to do something is for a federal district court to fine his lawyers, to fine individual officers, and hope the Supreme Court backs up those fines. And maybe there's a certain kind of irony that it is money that might be doing the talking at the end of the day for this president. It is, of course, no way to run a country, not at all. but one can only hope that calmer minds might prevail within the administration before we get to all of this. Okay, I'll stop now and take questions. This the microphone that we're using? Okay. Thank you.
Is it possible to ask you a question about an individual Supreme Court justice?
You can ask, yeah.
Okay. So I read Amy Coney Barrett as someone who is handcuffed by Catholic dogma as far as things like abortion are concerned, but I see her as probably someone who's going to be a Sandra Day O'Connor and be a fairly fair justice.
Yeah, I think there's a lot of evidence that has emerged in the past year or two that she is the most interesting justice in at the Supreme Court. She has joined the 3 liberal justices more than any of the other conservative justices over the past year and a half, and a bunch of high-profile rulings. It's been her and the Chief Justice more likely to do it. And I will say, as a personal matter, she is a very kind and thoughtful, lovely person who listens, is compassionate, listens to all of her colleagues, is not, I think you used the phrase, and Senator Feinstein unfortunately used the phrase dogma to respond some of her religious. And I understand, but when she was an unknown quantity, you could see the historic strain in her biography that might make you worried. But I think, listen, the Supreme Court would be a lot better if we had 6 Amy Coney Barretts plus the 3 liberal justices.
Just want to share something. I went to the demonstration they had at the Capitol, and it said, if this was really about getting rid of criminals, why did you elect one as president?
No comment.
How would the fines be imposed and collected?
Yeah, right.
What's
So
the mechanism for
good,
that?
right? Yes.
And then a second question, what about the Supreme Court's ruling on immunity? How does that impact the contempt citation
Yeah.
ability?
Good, right? So there's an outstanding court order against a person when they owe money to a court. Sometimes people just pay up, right? We can assume maybe not in this instance. So sometimes courts have to get help to enforce their judgments. They have to ask the United States Marshal to attach property or bank accounts belonging to the individual. But here's the difference, right? Whereas with the arrest order, the real question is, can this person be put in jail right now until they comply? That's the pressure, right? And they'll be like, oh, if I'm having to go to jail, I'm going to follow the order, right? The fines, maybe if you're Drew Ensign, the Department of Justice attorney currently defending the Kilmaro-Abrego Garcia case, you might say, oh, nobody's I don't have to pay the fine. The marshals aren't going to attach my home and sell it and kick me out on the curb. But that's only true while this president is in charge, right? That the fines, the order, that judgment persists. Maybe it can't be collected now, but unless Mr. Ensign's confident that Donald Trump is going to be president of the United States for the rest of his life, eventually the marshals are going to respond to somebody else who might say, yeah, you have to pay that fine that you owe. The criminal immunity, yeah. So I'm not convinced that that is what is motivating in a very logistical sense or direct sense the president's current actions. I don't think the president is saying, oh, if I could go to jail for some of what I'm doing, I wouldn't do it. Now that I can, I'm going to do all of these things. Because in truth, a lot of what he's doing, these are assertions of executive power that are not criminal. In a sense, there's no crime to try and save money for the American taxpayers. Might not be allowed under our system of separation of powers, but it's not a crime. But I do think there's maybe a subconscious signal. He thinks, right, and you saw it at the State of the Union address when he shook Chief Justice Roberts' hand and had read the room horribly incorrectly. He's like, thank you, John, I'll never forget this. As though John Roberts is on his team, and he's not. The Chief Justice is a lifelong Republican, very conservative, but he is not a Donald Trump Republican. So I think the subconscious message that Trump has received is the court's in my back pocket. I can do anything. And the only question is he right?
Question here. You mentioned earlier the fact that Congress has the power to make monies available for certain purposes. So for example, humanitarian aid in Africa would have been administered by USAID, but that's been eviscerated with offices closed. So how does the Impoundment Control Act apply when you're really talking about personnel?
Yeah. The USAID freeze, the Supreme Court actually has issued a ruling on $2 billion of the dollars that were for already approved contracts that were supposed to go out the door. And the Supreme Court said, yeah, that money's got to go out the door. 5 justices, Amy Coney Barrett, agreed that money has to go out the door. So this goes back to a little bit to what I was talking about, which is even if the administration loses on these cases in the long run, these cases take months before there's a final judgment. It is the fear, it is the uncertainty in the interim that the Trump administration is trying to accomplish, right? All the people who've been fired from USAID, Department of Education, who have now going over and getting new jobs. It may be that in a year the Supreme Court will back them up and say, actually, the president was wrong to fire you. Musk didn't have the authority to fire you. USAID can't be canceled. You get your jobs back. But A, in the meanwhile, that work is undone. People are suffering. B, a lot of people will just choose to stay out of the administration, given the uncertainty. So the law says one thing. The law says this money needs to go out the door. The president lacks the power to unilaterally rescind the funds. Lower courts are reaching those conclusions in the USAID and other cases. There's the question about what happens in the meanwhile.
I wanted to ask about Chief John Roberts. I noticed in several key decisions lately, he and Amy Coney Barrett combined to make a majority with the liberal justices. And I'm wondering what's your take on him?
Yeah.
Is he going to be like in the middle, sort of, or that misreading?
No, yeah, I think it's right.
Conservatism?
Yeah, the middle is so relative. So John Roberts is on the right. 6 justices are on the right. But the window, right, you've heard talk of the Overton window, right? The landscape, the wall, the board has changed, right? So, if this is the middle, and, Roberts is right here, and Barrett's right here, and then, Alito and Thomas are right here, right? It's not that Roberts and Barrett are moving to the middle. It's that what the president is doing is changing the landscape of constitutional litigation to be over here, right? The whole idea that a president can unilaterally cancel spending, that's not even, if we were in the middle, in the United States, that wouldn't even be on the wall. We wouldn't be talking about that, right? Shipping off somebody without due process, we wouldn't be talking about that in an ordinary system, right? And so John Roberts looks like he's in the middle because what the administration is doing is so far to the right.
I wanted to ask you about the letters or the executive orders addressed at law firms. If I understand it correctly, lawyers are officers of the court. Consequently, isn't that a direct attack on the judiciary?
Yeah, I think that's a fair way to put it. Yeah, I mean, listen, I think as a lawyer, I'm worried about the president targeting law firms, but I think it's also fair to say this is not the if you were like a Democratic messaging firm who's like, let's find the most sympathetic cause and let's put that in front of the American people, right? You wouldn't say big law firm, white shoe lawyers making $1 million in Washington, D.C., with their big fancy offices, that this is the people we want to put in front of the American people, saying, worry about these guys, right? But having said that, I think that's all true. Having said that, there is a concern. There is a concern if the president can chill, target lawyers and make it less attractive for them to represent unpopular clients who are going up against the Trump administration, right? Eventually what happens is there are no lawyers willing to sue the administration. We haven't gotten there. Luckily, a lot of actually very prominent conservative lawyers, including the former Solicitor General under George W. Bush, Paul Clement, has stood up and is like, I'm going to represent all of my lefty friends, and he's got plenty of them, and we will bring these lawsuits to defend these law firms and argue, as they do, that these orders violate the First Amendment, violate due process. So that's what's going on with that issue.
Okay, you've told us that if attorneys are charged with contempt of court for not following a Supreme Court order, that they can be fined and the fines accumulate and the federal government cannot bail them out. They can't reimburse them for the fines. What prevents someone like Elon Musk, who's an unlimited wealth, could allow him to reimburse them for these fines?
Yeah. This is a really, we're really out in, that's a great question. We're really out in uncharted waters. In theory, when a court is issuing a contempt order, it can attach conditions to its contempt order under what's known as its equitable powers, right? Its power to do justice, right? And if the court is worried that the contempt order itself will lose its meaning because the fines will just get paid by this really rich person, right? And that act of Elon Musk reimbursing this attorney will eviscerate the court's credibility, its power, its judicial power. In theory, the court can issue the same rule and saying, not only can you not be indemnified by the government, you can't be indemnified by any other individual, right? So the court could do that. I don't know if that is legal or not. I don't know if that court ruling itself violates some constitutional rights, some freedom of association, right? I don't know. In theory, that issue can be litigated, and at some point, the Supreme Court of the United States would be the one to decide it. We don't have clear, because Lord knows we've never had to deal with this before, right? So we don't have a clear answer, but it's a very fair question.
Hello.
Hi.
I have two questions. The first one, because we don't have an executive president who's that bright out the box, my first question, where does he get the ideas? Because some of them are right on point. I mean, he's hurting the American people with precision. So just to give us an idea, where you think he's getting the information that he's receiving to do this?
Yeah.
Because we know it doesn't come from him.
Yeah.
And then second of all, what do you think, in your opinion, will it take for this Congress to finally make a decision to stop,
Yeah, to do something. Yeah.
to do something?
Yeah.
Because they
Yeah.
do have the power to do it.
Totally. That's exactly the right question. That'll be a great place, maybe even to end, depending on where we are on time. Because that's okay. So where's the president getting these ideas? That's the big difference between Trump 1 and Trump 2. Trump 1, he's feeling his way out, looking for credibility, and all the people who are like, I'll serve in your administration, they're institutionalists, right? They're folks who respect norms, right? Even Attorney General Bill Barr, who's a very conservative man, is like, I will not prosecute political enemies. I will just not do that, right? So in Trump 2, when the president believes he has a mandate to do exactly what he wants to do, he's like, I'm not going to go back to that group. Like, I know my people now. And so he's got really good lawyers around him, really smart, good. That's a judgment. He's got very smart lawyers, folks like Stephen Miller, right, Jonathan Mitchell, who can very quickly identify the pain points and the ways that are least likely to be challenged in court, right? So that's answer 1. Number 2, what's it going to take for Congress, right? This is the elephant in the room, right? All of the actions that the president is taking that we feel worried about, troubled by, are actions that the president is taking because Congress has left this enormous back. Right? In a well-functioning democracy, Congress would pass laws on spending issues, on tariffs, right? That's who should be the first place to go, where the first place is to go. I'm not optimistic that something's going to happen, like just attitudinally, that will shift senators or representatives to start standing up and doing good. I'm not optimistic in part because they don't have the right incentives, right? We no longer elect serious people for the most part to Congress. Even in some ways, the Senate is more serious, less unserious than Congress. We elect performance artists, right? When you get elected to the Senate or the House, the very first thing you do is start to campaign for re-election, right? You don't go to Washington to pass laws. You get on your social media accounts and you try to own the libs. You try to own the conservatives, right? And the reason why our congressmen and our senators do that has everything to do with electoral politics, in particular with partisan gerrymandering, right? The only election that matters in most places in the United States is the primary. If you can win your primary in 5 of the 435 House districts, you're going to be the next congressman, because 405 of those districts are safe Democrat or safe Republicans. How do you win your primary? You go further to the left, because who votes in primaries? Far left people. Who votes in primaries on the right? Far right people, right? We have very little incentive for people to be serious. What it would take for Congress to do better is people who came to Washington, D.C. to compromise, to try to pass laws that actually help life for the American people and didn't care about political credit, political victories. We don't have those people. If you really want to know what would change that, it's for Congress to pass a law, which it could do on the very first day of a administration that's committed to this, ending partisan gerrymandering. Congress unquestionably has the Article 1 power to do so. The very first bill proposed in 2020 under the Biden administration was the John Lewis Voting Rights Act, which had a provision that would have required states to have independent redistricting commissions, map makers. Get this, who should make maps? Drawing districts? How about map makers? Not politicians, right? That would fix so much of Congress's malfunction. This administration, this Congress doesn't want any part of it. And if we'd had 2 more senators willing to carve out from the filibuster in 2020, we might have had it too.
All right. Well, thank you so much, Professor Tang. This was so great. Are you coming back next spring?
Sure.
I think there's unanimous approval for that.